This is Chicago's Morning Answer with Dan Prof on AM 560. The Answer.
Top of the morning, Dan Prof here. Molly Hemingway has a new book out on Justice Samuel Alito entitled Alito. She was on Megyn Kelly's podcast, that is, to discuss it in part. And one of the pertinent parts, particularly this week, is about leaks on the Supreme Court. The anecdote she shares pertains to the Dobbs decision. Of course, that was leaked. Leaker never found. I know Chris Wray was on the job, and I guess Kash Patel is now. Never found the complete lack of accountability, particularly when it comes to bad actors, ostensibly on the left. I don't know why it would have come from the right, but I don't know who it is. But I know how the left operates, and so does Molly Hemingway. And she provides some insight into how the leftist justices operated in the run-up to the release of the Dobbs decision. The leak is just a part of it. And since we had another Supreme Court leak this week, it's germane. But here's Molly Hemingway on that whole episode before the Dobbs opinion was rendered publicly.
When the decision was leaked, almost immediately you had massive protests, not just at the Supreme Court, but also fire bombings of pro-life clinics and churches, and you had protests at the homes of the 5 justices who had voted to overturn Roe. Those protests were, people were publicly putting out their addresses. Some of these justices live with their young children. They immediately had to be put under security. They were wearing bulletproof vests. They were dealing with things that nobody should ever have to deal with. And people were being kind of blasé about it. Now, because a decision is not final until it's publicly announced from the bench, even though there were 5 justices willing to overturn Roe and prepared to do that, it wouldn't be final. If one of them were killed, in fact, Roe would not have been overturned. It was clear that people were trying to either, God forbid, physically harm these people or otherwise intimidate them away from their decision. There are laws on the books against doing this. And yet Merrick Garland and the Department of Justice basically let everything continue, declined to prosecute in any way the people who were trying to affect the outcome. Congress did very little. The media were flat out cheerleading for these attacks on the justices. So yes, they meet in conference and they are asked, Justice Alito asks when it's going to be done, if they can speed it up. Gorsuch also is concerned. These people are facing really serious threats. And after that conference, my sources said that Elena Kagan goes to Breyer's chambers. Why Breyer's? Well, Breyer is a stalwart liberal, but he also is a gentleman, and he was concerned about what was happening to his colleagues. And Kagan reportedly screamed at him not to accommodate any kind of any kind of getting that dissent done so that the decision could be released. And the evidence suggests that...
It's despicable.
It's shocking. And then they finally agree. I'll just say one more thing that I think is just interesting about the inside of the court. When they meet in conference, they actually rate the decisions that have yet to come out as A, B, or C. A means they're totally ready to come out. B means that, you're just wrapping up the final bits. And C means nowhere near done. And in that first conference after the leak, Roberts says that the Dobbs decision is a C. A C. Now, wow. the guys who had the really hard work got everything done by early February, but the dissenters had made it a C. So they finally agree that they're going to get the decision done by June 1st. And they do. Their dissent, I should say, by June 1st. And they do. But when they do it, they put this little like evil Easter egg in there. They put a footnote to a decision that was not yet ready to come out, knowing that you can't reveal the outcome of a case that has not yet been publicly announced. It delayed the announcement of Dobbs for another 3+ weeks.
Sure, you got to give the guy who was plotting to assassinate Brett Kavanaugh as much time as possible and hope others come forward. Go right up until the 11th hour, even though you know your colleagues on the bench are being harassed, threatened, targeted. So that was the first of 3 leaks from the Supreme Court in the last 4 years. We had the leak as to the presidential immunity issue. And we had a leak this week to the New York Times about the interim docket, the so-called shadow docket. Carrie Urban is Fox News Channel's legal editor. She addressed this latest one in context of the other 2.
We're looking at 3 major leaks over the last 4 years, which is really unheard of for the U.S. Supreme Court.
Okay, so why?
It's a great question, Sandra. And look, I think these leaks tend to go in one direction, and it is to undercut what the conservative wing of the Supreme Court is doing or is in the process of doing. Certainly that was the case with Dobbs, and we saw what happened there when that decision was leaked. The justices faced violence at their homes. Attorney General Garland, unfortunately, didn't enforce the law at the time that would have stopped the protesters from doing some of the things they were doing around their homes. We remember that time. It was really troubling. It was the same time where that man attempted to murder Justice Brett Kavanaugh. It had some real world possible harms that could have occurred. And so why is it happening? Look, I think there are some disgruntled people that elections have consequences, and a Republican president has made some pretty conservative picks for the Supreme Court, and there are people who are unhappy with that, so they're willing to undercut and bypass the traditions and protocols of the Supreme Court and endanger its future, really, by leaking out things from that building to the general public who don't have the context and are certainly undercutting the public's trust just in the integrity of the institution by doing so.
Yeah, and you have a problem on the left where you have a substantial segment of those neo-Marxists who believe that violence is a legitimate means to political ends. There's that problem layered in here. For more on this and other matters, Professor Richard Epstein joins us. James Parker Hall, Distinguished Service Professor, Emeritus of Law, and Senior Lecturer at the University of Chicago. He has a new book out, timely, The Myth of Birthright Citizenship, that is available May 1st. The Myth of Birthright Citizenship, Professor Richard Epstein. Professor, thanks for being with us again. Appreciate it.
It's always nice to be with you, Dan, and to hear such cheery news about the Supreme Court.
Well, what's your reaction to these leaks? Yes.
Look, I mean, it's beyond terrible. I mean, one of the things that always used to work was a sense of comedy. And what that meant is I will behave well today and the understanding that you will behave well tomorrow. And that completely broke down about 25 years ago on the question of whether or not you could get a qualified Hispanic on the bench. And what the Democrats did is they decided to filibuster and force the thing away. And once you do that on the one side, then the other side retaliates. And so instead of having a sequence of situation of we bless your candidate, you bless my candidate, what you do is you have a situation where everybody tries to undermine the other person because they know there's no promise tomorrow. And it's really true that somebody puts in a footnote to a case that's yet decided in order to prevent the early publication of a case which will essentially diffuse some of the tension. That can only be described as dirty pool. And why is it that people do these sorts of things? It's they care too much about the outcome in some of these cases. And a lot of that is around so-called the birthright citizenship case. At this point, it's not so much what's going on the court because, I mean, they were miserable and totally incompetent in the way they argued the case. But that's not the point here. What happened is you start looking at the campaign that was done. I mean, it was a campaign almost of intimidation. Anybody who came out on the other side like I did didn't get a lot of friendship, and you saw all sorts of hostile things that were written, tasteless things written in the New Yorker, the New York Times. Even the Wall Street Journal, in its dignified fashion, came out on the wrong side of the substantive issue, but they were not part of a kind of mob-like activity that does this. And it's because, the ACLU did not just write a legal brief. They pushed a very strong political campaign on this stuff, and they were writing stories to discredit people who disagreed with them. The Supreme Court was completely unprepared for the case, is what the great tragedy is. The book that I write essentially does several things that they didn't bother to do. One of them is I read all the statutes that were involved in these cases and related them to the constitutional provisions. And so the most shocking and amazing thing about this is the Naturalization Act, which is a statute, a constitutional provision, which means that all the stuff that has to be done about naturalization has to be done by Congress. And they passed their first Naturalization Act in 1790, and I had never read it. And then I said, well, if I want to write a book about this subject, it might be wise to read it. And it begins as any free white person may apply for citizenship. Yeah. And so you look at that. Now, let me ask you the question that I asked myself, and somebody finally gave me the answer. Who was the first person to use that phrase in a naturalization statute before there was a federal government? What reactionary? Do you know who it was?
Before there was a federal government. Okay.
And so at that point, states had their own naturalization statute. And this thing passed without a peep. And then as you start going on, it gets even tougher in many ways. You have to be a resident of the United States. You don't have to be a domicile anywhere. And the Supreme Court got that all messed up when it worried about Juan Kimoff, the 1898 case that turned on, we were told, domicile. I mean, it had to be of good character and so forth. And then later on, it was made perfectly clear that you had to renounce loyalty to all of the sovereigns and so forth. So this was a very tough statute. And they did not repeal the ban on applications from persons of African descent until 1870, 2 years after the 14th Amendment went into place. And so the thought that the 14th Amendment gives you automatically citizenship, and so you don't have to go through this naturalization process, is just absolutely batty. Why would you have a naturalization statute that's liberated if large numbers of people have automatically gained that citizenship? Well, what they do is they say that all these people are subject to the jurisdiction of the United States.
Right.
But they completely get that wrong as well. If you go back to Blackstone, there are two major propositions. One, there's something known as local allegiance, meaning when you're in Rome, you do as the Romans do when it comes to paying sales taxes and following the driving rules. But the moment you leave Rome, you are no longer attached in any way to this. And so what happens is in the United States, local jurisdiction attaches to everybody under standard international principle. But you then read further, what Blackstone said is each nation has its own peculiar statutes on naturalization for internal purposes, and you can't infer what goes on from one to the next. And that's exactly what happened.
When
England,
go ahead, finish your thought.
Okay, well, what happens is in England, they did have a version of birthright citizenship that may be applied. But in America, when they passed the first statute, you had a federalism system that complicated things, and you had the institution of slavery that constituted complicated things. And they handled the slavery question by the white only. And they also well understood that the states could have their own requirements for state citizenship, which would not impair anything that was done with respect to the federal Constitution. And the federal rule, one of the key provisions was that the status of a minor children was determined by the status of a parent, which has always been the way this thing was done. So Justice Barrett spends a lot of time trying to separate the child from the parent so as to make birthright citizen work. And then she says, well, how do you acquire domicile as a child when you don't have an intention to do anything? Well, she never read the black letter law on this subject. The domicile of a child is determined by the domicile of its parent. And that was also true under the Naturalization Act. And so when she and when Justice Cadanzi Jackson go up there and start saying, well, we have to treat the individual child separately, it's in flat violation of standard rules on domicile. and in flat violation of the Constitutional provision. And that's, of course, what exactly what.
And so how much does the real world outcome play into the argument that you theorize? For example, I'm talking about the fact that nearly 10% of U.S. births in 2023, the last year where this data is available apparently, came from illegal immigrant mothers. 320,000 of the 3.6 million babies born in the U.S. in 2023 were so-called anchor babies. When you have that real-world outcome and you bump it up against the intent of the authors of the statutes in question, does that not provide more evidence to suggest this is something that the statute contemplated and wanted to preclude?
Look, the biggest blunder on this was Justice Roberts. I mean, he did not know what he was talking about. The first thing when the lawyer for the government comes up and says, there's a lot of planes now, and he said novel circumstances. It wasn't novel circumstances. The Chinese Exclusion Acts were all passed in the 1880s and 1890s to deal with a horde of people coming into this country on boats and then on trains. And sometimes these statutes were benevolent and sometimes they were vicious. But the one thing that was uniform about every one of the statutes and treaties was that they precluded naturalization of anybody who was led into the United States pursuant to these treaties. And what happens is he doesn't see that. Then, of course, he says it's the same Constitution. No, it's not. What happened is in 1885, when the Supreme Court first faced this question, what it did is it announced in one sentence, it is an inherent attribute of sovereignty that you have control over immigration. The actual American constitutional design, which was fully realized, was that the states controlled immigration and the federal government controlled naturalization. And it wasn't as though the states just had this idle power. You go back and you read all the cases and stuff, it was very effectively asserted against people and sometimes in rather ugly racist ways. And then they put it all into the federal government. And this received acclamation because by 1891 there was an immigration statute for which there was no original provision. And so the Chief Justice has this strange view of constitutional law that judges never change anything. But of course, in many cases, they change it powerfully. And so you're sitting there. This was a problem back in the 19th century. It's a problem in the 20th century and the 21st century. The Constitution changed. And by the time you got to World War II, there was a famous case called Hines and Davidovich, in which what the Supreme Court held, Justice Black, that not only was there a federal immigration authority, but that it completely preempted the state authority, which had been uniform about this issue 100 years before. That's the way American constitutional law works.
Speaking of that topic, I wanted a related topic I want to get your opinion on, because this is being kicked around in Congress right now, too, although I don't think it's going anywhere in the Senate, and that is temporary protected status. In this instance, it's with respect to 350,000 Haitians who have TPS protection. Some want to extend it, including a handful of Republicans in the House, and the president is intent on rescinding TPS. It's something the Supreme Court is going to tackle. Is it clear to you that the president has power over conferring or rescinding temporary protected status for a large group of immigrants from a particular country?
Well, it turns out it's a tough question because the president does have very strong powers on this stuff. But this gets back to the problem of the unitary executive where the president consistently overreaches. And what he's always saying is, I don't care what Congress says about anything. All the executive power lies on me. And if I decide these people go, they have to go. My view is he has to follow those statutes. And then on that issue, Congress can deal with something. This is not a constitutional question at all, because the immigration power and the naturalization power as we have simply allow the administration and the Congress to do anything. So if the Congress wanted to pass the statute of the naturalization, we hereby naturalize the citizens of the United States, all the citizens of China, that would be constitutionally okay. Politically, it might raise a problem or two. But so it's different.
Yeah, but
all the stuff having.
Well, but the Supreme Court, but you had temporary protected status provided by a previous president, and how could temporary protected status thus not be rescinded by a subsequent president? How does one bind the other?
Well, I mean, you're absolutely right about that. So to the extent that this is exclusively an executive authority matter, then that would be there. But what I'm saying is, since I don't know the particular statutes, if there was a congressional instruction to the president that Obama complied with, then Trump could not ignore that. But what you're right is, you look at the basic structure of the immigration statute and so forth, vast discretion is given to the current administration. And so Trump cannot be ruled out of bounds. But when you're doing all of this stuff, what you have to do is see what's going on. So just to give you something else which people don't understand, is the federal government has extensive and exclusive power over naturalization. Under the original Constitution, it had no power whatsoever over voting. It was an entirely a state matter. And that was not changed by the 14th Amendment. And so if you're technically looking at the Constitution, all voting decisions would have to be decided by the states on eligibility. And, we've gone past that by judicial decisions, and they're not going back, but that's just another illustration how these things are much more fluid in the way in which they go. And when the Supreme Court basically upheld Trump, on most of these cases, it was right in terms of the discretion. You may think the politics is bad, but that is not saying that it's unconstitutional.
Professor Richard Epstein is the James Parker Hall Distinguished Service Professor, Emeritus of Law, and Senior Lecturer at the University of Chicago. His new book, which we were discussing in part, at least the thesis of it, The Myth of Birthright Citizenship. The Myth of Birthright Citizenship is Professor Richard Epstein's new book, available May 1. Pick it up. Professor, thanks as always. Appreciate it.
Oh, and thank you for having me. Bye-bye.
And he joined us on the alphawealthgroup.com answer line.
It's like a hot, steaming cup of information to start your day. It's Chicago's Morning Answer on AM 560. The Answer.
You need a construction company, but who?
Call Crosscom.
A construction company you can trust that shares your Christian and conservative values. For decades, Crosscom has been doing work in Chicagoland, Northwest Indiana, and